Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing IR-1 visas. That's immediate relative visas. Those are visas to, in most of the cases we see these are visas where this is the spouse of an American citizen, although in theory we could be seeing cases of spouses of lawful permanent residents. But generally speaking, we're talking about spouses of American citizens, usually when we see cases processed out of here in Thailand. Now, an IR-1 visa is somewhat different than a CR-1 visa, as the holder of an IR-1 immediate relative visa enters the United States in unconditional lawful permanent resident status, as opposed to conditional lawful permanent resident status, which is the status in which someone holding a CR-1 visa would enter the United States. The question I get a lot with respect to marriage visas and fiancé visas throughout the process is, when should we change our name? And that's usually the case where you've got a Thai female who's married to an American male. They're wanting to travel to the United States, and they've already been married. Usually they've been married for quite some time where I'm dealing with IR-1 visas. The situation with respect to visas associated with the name change, the questions I see, I should say, are when should we do it? And my advice is usually either before we ever start this process or at the very, very foreseeable end. And what I mean to say by that is, before you ever get an immigration petition on file, if you want to change your name, do it before then. Because changing it midway through the process is problematic, to say the least. It adds layers of complexity with respect to forms associated with identification. Most notably, things like passports likely have to be replaced, Thai ID cards, things of that nature have to be replaced because you have to change the name. Then on top of that, you have to deal with the translations associated therewith, which has to be changed. And it's just problematic, especially midway through the process. If you wait till the very end, and by the end I mean presumably if the Thai spouse comes to the United States and wishes to apply for naturalization to United States citizenship, at the time that they naturalize, they can pick their own name when they naturalize to American citizenship. It's sort of a plenary aspect of the naturalization process. And for this reason, it's probably a good idea to wait for that because it's relatively straightforward. And after naturalization, prior immigration documentation is largely irrelevant because you're now naturalized to U.S. citizenship. But if you really want to do it, I think it's a good idea to do it before the process ever starts or at the very, very end, because doing it in the middle results in a lot more complexity to a situation that's already complex enough to deal with.